Hey everybody, welcome to Network for Law Students and Lawyers. So it's about that time of year for final exams, and I know some of you law students are anxious about it. In this video, we're going to talk about some law school final exam tips. So if that's something you're interested in learning about, just keep watching. Sleep before the exam and eat properly because you know that already, and I'm not going to waste your time. A lot of law student videos about that, so in this video, we're going to be getting into the details. Make sure you know which topics will be included on the final exam. Meaning, is it cumulative? Does it cover topics discussed the whole semester or just your midterm? Ask your professor, not your fellow law students. Don't leave any points on the table. Make sure that your exam is complete. Make sure it has the number of pages that the professor said that it was going to have. Even if you're taking an open book exam, prepare for it as if it were a closed book exam. Even if it's open book, it's still probably time, so you will have no time to really flip through to get the notes or other materials. Make an attack outline. List all the topics covered over the course of the semester and memorize that. Excel spreadsheet. So create an Excel spreadsheet like an index where you could find all of the information if you're taking an open book exam. Both multiple choice and essay exams, you should try to read the call of the question first. It will focus you in the way you need to be focused. That way you could look for those particular issues related to the call of the question as you are reading the hypothetical. You can start thinking about which rules apply. Help the reader of the exam. Your professor in most cases. And to get as many points as possible, help them help you. Keep in mind that they're reading essays for not just you, but for everyone in the class. So one way you could do this is by giving the reader's eye some visual relief. This is where your training in legal practice and legal research and writing come in. In that class, you were probably taught how to craft headings. Do this for your essay exam in the other classes. The headings should include some law and some facts. It's basically a sentence summary of what your analysis will entail. And don't think that this is a waste of time. I do this now as a licensed attorney in drafting court documents. Well, yeah, by the way, I've been a licensed attorney for about a month now. I was sworn in October 2020, and I'll be posting a video on that shortly. So an example, you're an associate of the law firm Crane, Poole & Schmidt. Mr. Neosporin, a teacher in high school and a former Iraqi veteran, wants to file a lawsuit alleging intentional infliction of emotional distress against the employer, Sesame Street School District. Mr. Neosporin alleges that an unannounced school shooter drill, ordered by his boss, caused him to suffer emotional distress because he thought there was an actual school shooting. Ms. Cruella DeVille, the boss, a gun enthusiast, decided to play the audio from an old news taping of the Vietnam War for effect during the drill, which was approved by her supervisors because it would be more realistic. For several weeks since the fire drill, Mr. Neosporin experienced a loss of sleep, noise sensitivities, headaches. Your boss, Denny Crane, has asked you to prepare a pretrial brief on two of the elements of intentional infliction of emotional distress: extreme and outrageous conduct, and severity of the distress. Bad. Cruella DeVille acted in a crazy way, and I think that should never be tolerated. Note, the school is being sued, not the boss. Crazy is subjective and not an element of IIED, and what you think doesn't really matter. It's supposed to be in the objective tense. A good point heading would be Sesame Street School District engaged in extreme and outrageous conduct when it allowed the execution of an unannounced controversial school shooter drill. Going to the second element, severity of the distress. A bad heading would be Mr. Sporn suffers severe distress, thereby the element of IIED is satisfied. What's wrong with that is that they abbreviate IIED without first saying it in a parentheses or a quote, like intentional infliction of emotional distress, parentheses, hereinafter IIED. There's no facts here, just a legal conclusion. Remember, the good headings have law and facts. Another bad one would be Mr. Sporn can't sleep, sensitive to noise, and can't leave his house. Well, that's just stating the facts that have already been stated in the fact pattern. You don't need to restate facts that have already been stated by the professor in the fact pattern. A good one would be, Mr. Neosporin suffers from severe distress because he is plagued by the loss of sleep, headaches, has to take prescribed medications, and has been diagnosed with post-traumatic stress disorder as a result of the drug. Even if you don't have time to do an actual practice exam, if you have a chance, at least look at an old exam from your professor. Please do so. Maybe you'll see a pattern in what is tested, but you'll certainly be able to get a feel for how the questions are being asked. If there's samples answers, read over those as well. Get a sense of how the professor prefers that you write your responses. When I was in law school, I tended to write very long rule statements. I'd state the rule, but then I'd do what they call a rule explanation. I would talk about the notable cases that the class studied about each topic. I'd compare and contrast the fact pattern from those cases. After all, that's what you're going to do once you graduate. Timing. I know that some of you have problems with timing, especially on multiple choice sections. Practice questions with a timer, and then you'll instinctively be able to feel when to move on. And I did this with other things, not just with practicing multiple choice questions. I calculate exactly how much time I had for the multiple choice questions on the exam. So if I had 1 minute and 45 seconds, that's how much time I'd allot for the practice questions, but then I do other things during that time too, like doing 1 minute and 45 seconds worth of jumping jacks, or brushing my hair for 1 minute and 45 seconds, just so my body would get used to when it's time to stop. Longer does not always mean better. Just like some people tend to talk a lot when they're nervous, some people write a lot when they don't know the answer. Having an overly long response can indicate to the professor that you're just throwing everything you know on paper just to see what sticks, and you don't understand. List all the cases you studied for the entire semester on a piece of paper. I'm not saying to reread those cases, but first list them under each subtopic of the course. Then go back to that list and organize the cases even further. List them according to what were examples of the concept and where the argument did not work to illustrate the concept. Ultimately, that will give you arguments from both sides in the exam. Which cases would each party use to support their argument? Kind of like a tennis match. Point, counterpoint. IRAC stands for Issue, Rule, Analysis, and Conclusion, and it comes in a variety of forms. It's just a way to organize your exam. Your new mantra should be assume nothing, define everything. Every time you mention a new legal term for the first time, define it. Write your exam ahead of time. I know that sounds crazy, but make sure you check out the video I did on learning styles. I'll pop the link down in the description box below. I'm primarily a logical mathematical learner, so what I do is write down everything I knew about each topic. Then I memorize at least the number of different things that I wanted to include in a rule statement. For example, if I wanted to talk about negligence, I knew I had to cover the 4 elements of negligence: duty, breach, causation, and damages. If you're running out of time but you didn't get to address all the issues that you wanted, just throw out IRAC and create a mini heading with a quick analysis. An example of that would be, there would be no issue of larceny here when the teenager took her mom's car with the permission of her dad on a joyride to get the new iPhone and bring the car back because the teenager did not have the intent to permanently deprive her mother of her interest in the car. Abbreviations. Don't use abbreviations without first writing the whole word out and then in parentheses with the abbreviation in quotes. So intentional infliction of emotional distress, parentheses, IIED. Similarly, do not write your own shorthand. Like what I said before about negligence. You have to define what a duty is, from whom to whom. What's a breach? What's causation? And how many types are there? What's damages? Just like there's no I in team, again, you have to write it objectively, not saying I believe in your exam. Make sure you follow the directions, and I know that sounds overly simplistic, but you'd be surprised how many law students and people taking the bar don't do it. If the exam says draft the memo, then draft the memo. For the facts section, don't repeat the facts, just put something along the lines of facts omitted. When I was in law school, there was one student who didn't read the instructions and missed a whole page of multiple choice and fill-in questions and didn't do well as a result. So make sure you know how many questions and what type of questions should be on the exam beforehand. Maybe ask your professor if they would be willing to email you the directions before the exam so that you can familiarize yourself. Anyway, I'm going to wrap up this video here. Be sure to check out more tips on our totally free course on Thinkific. Bye for now. Thank you for listening.